Greetings and welcome. Let's stop this timer here. Okay, greetings and welcome to the Law Merchant. We're going to get right into this. If you just arrived, please hit the like. And let's get started. So this is coming from Introduction to Law Merchant. Give me a moment here to adjust the view here so we get a better look at the text. And let's get started here. So, the introduction to Law Merchant. Before we get started, just to remind everyone, this broadcast is strictly for the entertainment educational purposes of this YouTube channel, not to be used, misconstrued, or abused for anything legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. Let's get started. Table of contents. We have an introduction defining the lex mercatoria and law merchant, commercial law, substantive law, maritime law, admiralty law, administrative law, and positive law, foundation for the law merchant principles, security interest, court of equity, law merchant admiralty and common law, imprisonment and security interest, merchants create money from debt, statute merchant, statute staple, medieval European fairs of the merchants. Wow. And then the summary. Let's get started here. Emphasis is added throughout this writing by underlining. Quoted passages are bolded. Geez. Nice. Good thing they bold-faced this. I guess that means that's a quote. But I digress. Let's get started here on the introduction to Law Merchant. Stand fast, therefore, in the liberty with which Christ hath made us free, and be not entangled again with the yoke of bondage. And that's from Galatians. The law merchant is, in fact, an independent, parallel system of law, like equity or admiralty. The king's courts administered, not local custom, nor even the custom of the realm, but rules applied in commercial causes in all countries. The negotiable instruments law, however, expressly adopts the law merchant, not the rules of the common law, as to matters not covered therein, and this court is required to take judicial notice thereof. Wow, and that's from Bank of Conway versus Starry, 1924. So this is interesting. The negotiable instruments law expressly adopts the law merchant, not rules of common law, as to matters not covered therein. And this court is required to take judicial notice thereof. And we did do a nice whole session on judicial notice on the American Jurisprudence playlist on this channel. So let's get to our treatise and the introduction to Law Merchant. To be free with liberty, and not becoming someone's slave by not being subject to the will of another, requires knowledge and understandings of the methods of deception. So, to be free with liberty requires knowledge and understanding of the methods of deception. So it doesn't say to apply them, but to have knowledge and understanding of the methods. But who looks into the perfect law, the law of liberty, and preserves and perseveres, being no hearer that forgets, but a doer that acts, he shall be blessed in his doing. And that's from James. Be not ye the servants of men. And that's from Corinthians. Stand fast, therefore, in the liberty with which Christ hath made us free, and be not entangled again with the yoke of bondage. And there's Galatians again. So I think the reason for these Bible quotes here is the fact that, like it or not, that the Christian religion is a part of our common law, and this is also putting the distinction that anything not contained within the common law would be applied to the law merchant. All right, let's continue here. The following addresses to the merchants as the great or notorious men of the earth and the deceptions involved in the commercial system of Babylon or elsewhere. And the kings of the earth who have committed fornication and lived deliciously with her shall bewail her and lament for her when they shall see the smoke of her burning. Yikes. Standing afar off for the fear of her torment, saying, Alas, alas, that great city Babylon, that mighty city, for in 1 hour is thy judgment come. And the merchants of the earth shall weep and mourn over her. For no man buyeth their merchandise any more, including slaves and souls of men. And the fruits that thy soul lusted after are departed from thee, and all the things which were dainty and goodly are departed from thee, and thou shalt find them no more at all. The merchants of these things, which were made rich by her, shall stand afar off for the fear of her torment, weeping and wailing. For thy merchants were the great men of the earth, for by thy sorceries were all nations deceived. Yikes. And that's from Revelations. Okay, enough Bible thumping, let's get on. Introduction. Not only does the Bible address liberty and the importance of avoiding slavery in all its aspects, but America's early statesmen advised and warned the American people to remain free, proclaim liberty throughout the land, and not to become servants or slaves of others. You might think it would be relatively easy to remain free and out of the yoke of bondage. If you are unaware of the various cunning and deceptive methods used by certain associations or merchants of the earth, it may surprise you how sophisticated is the practice of deception. All right, before we get going further, let me just check in with the chat, make sure I'm coming through loud and clear. Wanda Mice, good to see you. And if audio is all good, just give me affirmative at some point. If not, please do let me know. Let's continue. While the Bible served as a foundation of the common law of the American people initially, see, as I was saying here, it is a foundation of our common law, or a part of it, I said, but they're saying it's a foundation of our common law of the American people initially. Today, the rules and customs of merchants, known as the law merchant, reign supreme. The rules and customs of merchants is the law merchant, and it reigns supreme. This writing will look at some of the history and practices of the global merchants. All right, we're all good? Excellent, thank you. How can foreigners use the principles of the law merchant to create statutes, regulations, and codes, thereby becoming the major source of law and justice? The reason many believe that America has a real problem with its current form of law and the manner in which courts operate is because the law merchant is designed for the purposes of revenue and control, creating various degrees of chaos. It is not for purposes of harmony, peace, honor, and moral qualities. So now we're tapping into the purposes, and that gets into the maxims. So could it be that law merchant has different maxims than common law? Seems it does. If one wanted to reap the fruits of the energy of a people, or obtain legal or equitable title to other natural resources within a country, how would one go about implementing such a plan? If you can get a security interest, which could lead to a valid title on the nations of the world, you could, in effect, control national governments, their citizens, and their property, as well as other national assets or resources. Security interest. If you can get a security interest which could lead to a valid title. Think about this now. This is a progressive encroachment which could lead, eventually, those security interests will ripen into a valid title. Perhaps, or at least a good percentage, maybe. If you choose some valuable resources that you would like to own or control within a particular country, rather than military conquest, you could make a loan to the head of state for a project that would be deemed beneficial to the people. Constructing oil wells, building a dam for the production of electricity, a canal, or other similar project would suffice. This is not to say that getting a nation involved in a war is still the biggest debt creator for which a country may seek the major financial lenders. The object is to get the president or appropriate public officials to agree to borrow money. Of course, those state officials who assist in getting a loan accomplished will be the recipients of financial rewards. So notice here, this is not to say that getting a nation involved in a war is still the biggest. Not to say that getting a nation in a war is still the biggest debt collector for which a country may seek. Okay, whether it is or not, the point is the object is not to get them just involved in the debt. The object is to get them to agree to borrow money. So if they're forced to because of war, then that's under a different type of agreement in the beginning, or conditions, I should say, maybe circumstances that could lead to a default more easily than if they agree to borrow money. An important element in the plan is assuring the country will be unable to repay the loan. Oh, surprise. Whatever resources within the country are used as collateral or surety for the original loan would then be under the control of the creditor. The creditor would acquire a security interest in a few and possibly all of the revenue-producing resources, as well as other things of value within the control of the debtor or national government. Other elements that need to be considered in this plan are that the country would need to be organized as a nation with a national government, which is deemed to be the sovereign head. This would be beneficial since the national government has authority over all the persons and property within the nation. Also, the subjects or citizens of a national government could be considered taxpayers, which represents another source of revenue for the repayment of the loan and as a collateral or surety in the event the national government defaults on its obligation. Just like other collateral, the creditor of the national government would have a security interest in the subjects or citizens of the national government. Upon default, either through bankruptcy, insolvency, or otherwise, the merchant lender or construction company could control legislation, executive, and judicial administrative acts or actions with respect to all persons and property of the debtor government and continue to receive revenue from all sources within respect to such persons and property. In essence, the citizenry, subjects, and valuable resources of a nation could be under the control of merchants who hold a security interest or have obtained whatever rights and title the debtor government possessed. Let's break over here to the chat for a second and try to digest this a bit. I see we got some talk here. Wanda Mai says, I know religion and law are referenced as being related, but I believe it's beyond that. I don't believe law was written, but it's more of an understanding of moral character. It is, but it has to be written to be codified because as the maxim of law goes, the spoken word flies, the written letter remains. So to codify this stuff makes it so it's not just talk. Writing is a way of getting everyone to agree on something. Oral contracts, as I said, are too hard to enforce after the fact or by third parties. Craig Carey says, good plan. Put them in debt so they can plunder their own resources for you. Yeah, codified for civilization. Anyone that's going to participate needs to go by the same rules, equal laws and equal rights. Let's proceed here. Maybe you think this is an unbelievable scenario. John Perkins is a man who worked for the major merchants of the earth. He wrote a book recently entitled Confessions of an Economic Hitman. I think many people have heard this, and there's been a good video on YouTube actually about this, wherein he describes his work as illustrated above in the scenario for getting a country into debt and controlling its resources. because it will be unable to repay the loan. If the country's president refuses the loan arrangement, it is then necessary to replace the president or other person who becomes an obstacle to the fulfillment of the plan by whatever means necessary. Interesting there. Whatever means necessary. If you understand modern banking practices, fractional reserve banking, and paper currencies, you realize the creditor banking merchants may not have actually used their money in making a loan to the head of a state of some nation. Depositing and marketing the promissory note or other evidence of indebtedness would make that commercial instrument the source of the funding of the loan. That is to say, it is possible a paper that appears to be evidence of indebtedness is also at the same time an asset to create funds in the international markets. A commercial instrument on paper. We saw that in a previous one, and I think I could bring up a document here that would be rather interesting. Give me a moment here, and let me see if I can bring it up about the 7 points of a commercial instrument. I was able to get that, but it was after the live stream, so I think it would behoove us to bring that up here and take a quick look at it. Give me a moment here. Switch this thing over here to get to what we need. Come on. All right, bear with me just a moment. I think that should work here. Okay, there we go. All right, let me jump over here. This, okay. Can't really zoom out from that. Can we all read this? Yeah. All right, well, you just can't read the title there. It says the 7 essential points that must be included in a commercial instrument or process to ensure full disclosure and accountability. So when we talk about, they say that word commercial instrument, well, what are the 7 essential points to that commercial instrument? 1, identification of all relevant parties. 2, a sworn statement of facts. 3, an explicit listing of obligations and remedies. Explicit listing of obligations and then remedies. So if there's a problem, how do we remedy the problem here? A pledged surety or collateral. Supporting exhibits and evidence. And certification of the accuracy of the allegations. So we have someone witnessed identification of the affiant. The following 7 points helps ensure that the instrument holds up legally and the parties cannot later deny what was agreed upon or owed. So this is what constitutes the 7 essential points of a commercial instrument to ensure full disclosure and accountability. So with this, we have something that's be considered the evidence they're speaking of in here. So let's get back to the text here. Oh, geez, hang on a second. There we go. Okay. The promissory note or other evidence of indebtedness would make that commercial instrument. So the promissory note or other evidence of indebtedness would be the commercial instrument, the source of the funding. So all those 7 points have to be contained in a promissory note or other evidence of indebtedness. Would make that commercial instrument the source of the funding of the loan. That is to say, it is possible a paper that appears to be evidence of indebtedness is also at the same time an asset to create funds in the international markets. So the promissory note or other evidence that commercial instrument is the source of funding. That is the collateral for the international markets. However, for the we also have a pledged surety or collateral in there in the commercial instrument. So that commercial instrument, that paper, appears to be evidence of deadness, at the same time an asset. Wow. At the same time, it becomes an asset, which can then be, again, pledged as collateral. Think about this. A promissory note is then pledged as collateral, as an asset to create funds in the international markets to be fractionally reserved, apparently. To summarize this scheme, one could say that after obtaining ownership, control, or a security interest in the resources of a nation, the merchant bankers or contractors could obtain a status or position superior to the debtor government of a nation. Wow. In this position, they could control and regulate the activities within the nation like a shadow government or an invisible government, providing written legislation for the existing legislative bodies to adopt or enact on their behalf. There's one level of deceit right there, to corrupt the written legislation. This legislation would be based upon the lex mercatoria, or law merchant. One might say the great merchants are developing Babylon-like cities and nations around the globe. Ooh, that's pretty deep. And with that, let's get over here. Why am I saying participation? Who participates? Even state courts are participation authority. Well, it depends on what level here. And just to focus on the law merchant here, we're talking about commercial relationships here and participation in a commercial system. As we said here, the international markets. So we're looking at international commerce, not just domestic, when we're discussing law merchant. All right, so we're here to defining lex mercatoria and law merchant. The law merchant is often described as the body of rules applied to commercial transactions derived from the practices of international merchants and traders. Derived from the practices. So it's a body of rules applied to commercial transactions derived from the practices of international merchants and traders. International. However, the scenario depicted above and other historical writings show that customs or rules of the merchants is likely to be integrated into the general law or jurisprudence of the debtor nation, or as a result of their influence, financial or otherwise. See this? So the jurisprudence of a nation is corrupted. Here's another level of deceit. The customs or rules of the merchants is likely to be integrated, what a nice use of euphemism, into the general law or jurisprudence, of the debtor nation, or as a result of their influence, financial or otherwise. Interesting there. So law merchant, a system of customs acknowledged and taken notice of by all commercial nations. So it's a system of customs acknowledged and taken notice of by all commercial nations. And those customs constitute a part of the general law of the land. Part of it. So Christianity is part of our common law, and the law merchant's part of our general law of the land. And being a part of that law, their existence cannot be proved by witnesses, but the judges are bound to take notice of them ex officio. That's from Bouvier's dictionary there. We could take a digression into Black's law, but they may do this in this text. If they don't, remind me in the chat and we'll go and look up law merchant, or maybe it's merchant law. There's a comma here. We'll look at both ways in Black's if we go there. Law merchant, a body of rules for regulating the relations of merchants engaged in international trade. It was founded upon the customs of merchants, which were sometimes embodied in the written rules, such as the Laws of Oleron, a code of maritime law, published in the 12th century. Law merchant originated in Western Europe during the Middle Ages and was subsequently recognized by the principal commercial nations. Although it was first administered by separate tribunals in the principal trading cities, it eventually became part of the domestic law of the countries in which it flourished, including the United States. Law merchant was the basis of the modern system of admiralty law and the laws of negotiable paper and of sales. See Maritime Law. That comes from the American People's Encyclopedia from Grolier, 1968. The law merchant went from being principles and rules applied to international merchants and traders to being incorporated into the general laws of a country. In effect, the law merchant, merchants being the great men of the earth, took control of admiralty law and the common law of England, which was then adopted into the laws of the states and the United States. Commercial law, the laws that govern business transactions. Formal documents and other evidences of regularized trade practices were known in Egypt and Babylonia. In many parts of the ancient world, foreign merchants, through treaty arrangements and other agreements, were allowed to regulate their affairs and adjudicate their own disputes without interference from local authorities. Without interference from local authorities. They tended to settle in special sections of commercial cities where they might follow their own religions, laws, and customs. Roman law incorporated features of the already developed commercial law, which, however, was no longer handled separately in special courts, but was treated simply as part of the whole legal system. Interesting. So it was, instead of having special districts, special sections of commercial cities where they follow their own religions, laws, and customs, Roman law incorporated the features already developed in commercial law, which, however, is no longer handled separately in special courts, but was treated simply as part of the whole legal system. The barbarian invasions of Europe caused such a social disruption that it was not until late in the Middle Ages that the long-range commerce again became possible in Europe, and the merchants were once more able to determine the rules and regulations under which they could safely operate. In the cities of North Italy and South France, the merchant class frequently dominated the state and could enact the needed rules as legislation. In other parts of Europe, associations of merchants brought protection from the powerful lords or kings, the state, who granted them safe conduct and permitted them to conduct fairs and to establish regulations and methods of enforcement. Wow, see, Hanseatic League. Both classes of merchants exhibited special courts where summary judgment was granted with little regard for the technicalities of procedure and doctrine in the regular courts, and without the necessity for lawyers. The term law merchant was applied to the substantive principles that eventually emerged from this quasi-judicial activity. And that comes from the Columbia Electronic Encyclopedia, 2005. Law merchant, consisting of certain principles of equity and usages of trade, which general convenience and a common sense of justice have established to regulate the dealings of merchants and mariners in all the commercial countries of the civilized world. The basis of the jurisprudence, regulating bills of exchange, and promissory notes, particularly the negotiability of such instruments, and the rights and liabilities of persons becoming parties to the instrument persons. So this is technically legally a dead entity and can't be a living man or woman. The lex mercatoria was not, like the common law, the custom of a place or territory. It was the recognized custom of merchants and traders. So we know customs usually are associated with the geographic area. But these customs are the customs of merchants and traders. The merchant class and the controversies of its members arising out of commercial transactions were not subject to the common law. During the 16th century, the Admiralty Court declared the principles of the law merchant. Later, the common law judges encroached upon the field of admiralty over commercial transactions. Thus, the law merchant gradually became a part of the legal system of England. Wow, that comes from Ballantyne's Law Dictionary, 3rd edition, 1969. So the common law judges just wanted a piece of the game, is what it was. First, it should be said that the rules of commercial law or law merchants are not the problem. It is the deceptions and illusions, the trickery, that cause enormous problems and disharmony wherever the great merchants apply their trade. In the foregoing, we find that principles of the law merchant go back to Babylon. The major merchants desired to be exempt from the laws of a country or place wherein they might conduct business. They sought to have their own rules and remedies handled in special courts. The procedure of these special courts would later become integrated into the regular courts, making the regular courts irregular. The regular judicial courts might be given a new name, but most people would be unaware of the change. The merchants could establish their own rules and regulations, which eventually might become part of the general laws of the country and be enacted by the legislature that would benefit the merchants. The merchants might make payments to political officials in exchange for the passage of legislation and for the protection of their trade or other benefits. While we have seen it reported that the law merchant, rather than be separate and special, become part of the legal system, it may also be appropriate to say today that the law merchant became the legal system. Let's jump over here to the chat and see if... Pretty slow notification, it seems, tonight. This is a very interesting topic. I hope you all are still with me. Let's continue. We shall later see the deceptions involved banking and lending and obtaining security or beneficial interest in assets through the illusion of being a creditor. The illusion of being a creditor. In the following quote, the author gives the term lex mercatoria a broader definition than merchant law. The lex mercatoria would seem to be, in part, based on Roman law, in part, maritime custom, in part, the law of the medieval European fairs, and to a great extent, upon the last. Wow. Medieval European fairs. Here we have coupled together Roman law, the state is God, maritime law, international law of war and commerce, and merchant law, which is the present day law of national and international banking. The law of negotiable instruments, with a few exceptions, is founded entirely upon the customs of merchants, known today as the Uniform Commercial Code. Let's read that again. The law of negotiable instruments, with a few exceptions, is founded entirely upon the customs of merchants. It's known today as the Uniform Commercial Code. Interesting. So now we see how they've pushed that in there. Of course, the UCC, the Uniform Commercial Code, is not law, but it has been integrated within a lot of, we should say, statutory law or statutory regulations would be a better term. That comes from a student's course on legal history and history of the law merchant. Wow. From Handbook of Roman Law by Max Radin, professor of law, we find three categories listed under law merchant are 1. Negotiable instruments, 2. Bankruptcy, and 3. Insurance. Oh boy. So those are your three things for law merchant: negotiable instruments, bankruptcy, and insurance. Another way of looking at those categories would be that the law merchant deals with creditors and debtors, with liability, with security, or things of value, that can be used as collateral by debtors for the security of a creditor and with protection from financial loss. Protection from financial loss. Okay, so law that deals with liability and security, creditors and debtors. Things of value could be used as collateral with the protection from financial loss. So let's see here. In the American People's Encyclopedia, commercial law embraces principal and agent, bills and notes, insurance, carriers, surety, and guarantee, and other titles. For origins of commercial law, see law merchant. So embraces principal and agent, bills and notes, insurance, carriers, surety, and guarantee. So that's the, I guess this is another way of what different sources define commercial law as, and the lex mercatoria, and where you can see the variations in here. But essentially, I think this is just another layer of the deceit of how this stuff embraces, words like embraces, principal and agent, and then by embracing them, injects them into our laws. 3. Law merchant, commercial law, substantive law, maritime law, admiralty law, administrative law, and positive law. Man, terms listed in the heading above have a common meaning, and these terms are often interchangeable with one another. Now that's interesting. Let's jump over here to the chat before we get on to section 3 here. Diesel for We the People News says, and this is the reason why some people actually use the UCC in court fees to be either taxes, in court fees to be either taxes or law of merchants. Not too sure, but I think I got kind of lost in the typos or the text to, or speech to text. Nevertheless, let's continue here. You can retype that one in. These terms are generally associated with an unnatural order of things. The treatise, The Natural Order of Things, explains that the natural order begins with God or Creator, who created men, who form a state for their benefit, followed by a constitution to establish and limit the activities of a government. So that's the natural order of things. God creates man, forms state for their benefit, followed by a constitution to establish and limit the activities of the government. In the unnatural order, the government claims to be the state and is deemed to be the supreme entity with sovereign powers. We saw an earlier quote, a reference to Roman laws meaning the state is God. There cannot be two gods. Therefore, all references to God must be removed from the public places. This is the environment desired by the great merchants. A national, sovereign, political, central government with citizen subjects, quasi-slaves, owing fidelity and obedience to the national will. In the treatise, The Negative Side of Positive Law, we see Black's Law Dictionary 4th edition say positive law is enforced by a sovereign political authority. It is distinguished from the principles of morality and the so-called laws of honor. All laws that are authoritatively imposed may be described as positive laws. Authoritatively imposed, so from some authority or imposing, and we call those positive laws. From Black's Law Dictionary 7th edition, we find positive law as a system of law promulgated and implemented within a particular political community by political superiors, as distinct from moral law or law existing in an ideal community or in some non-political community. Wow. The terms political community and body politic and corporate are all important terms in understanding the overall picture of the unnatural order, but that topic will not be fully explored in this treatise. Commercial law, a phrase used to designate the whole body of substantive jurisprudence. Example given here is the UCC, the Uniform Commercial Code, Truth in Lending Act. So commercial law is a phrase used to designate the whole body of substantive jurisprudence, applicable to the rights, intercourse, and relations of persons engaged in commerce, trade, or mercantile pursuits. CUCC, that's 6th edition of Black's. Law merchant, taken as meaning substantive law. Substantive law, the positive law of duties and rights. That's from Cochrane's Law Lexicon. Related to the substantive social policy embodied in an act of positive law. The current legal system, evolving from the Civil War era, is composed of substantive law and procedural law. Substantive law concerns duties, rights, and obligations, and includes criminal law. Procedural law provides the methods used to enforce those substantive duties, rights, and obligations, including convicting a person of a crime. This is all under commercial law or law merchant. Think about this now. Substantive law and procedural law, the current legal system. So the substantive law concerns duties, rights, and obligations, and that's criminal law. Procedural law provides methods used to enforce those substantive duties, rights, and obligations, including convicting a person of a crime. This is all under the commercial law or law merchant. So we see how law merchant, commercial law, substantive law, positive law are not only related to one another, but are practically synonymous terms. The one thing I am reminded of when seeing the term positive law is that it is said to be the only type of law that can support slavery. Positive law is a concept that someone or somebody has such a degree of power that he may act in any manner, and may act in a manner contrary to the laws of nature and nature's God. Positive law comes from a sovereign political power. I do not believe such a concept exists in law, but perhaps in a religious or spiritual connotation as to defy the word or will of God. Wow, that's pretty deep there. The author here says, I do not believe such a concept exists in law, but perhaps in a religious or spiritual connotation as to defy the word or will of God. So positive law is going against the word or will of God. That slavery is a relation founded in force, not in right, existing where it does, by force of positive law, and not recognized as founded in natural right, is intimated by the definition of slavery in the civil law. Wow, that's from 1836, Commonwealth versus Aves. That slavery is contrary to the principles of natural right and to the great law of love. That is, slavery is founded on injustice and fraud and can be supported only by the provisions of positive law, or positions which it is not necessary here to prove. The very idea of slavery implies that the slave is one who is in subjection to the will of another. Earlier quotes said that substantive law is the positive law of rights and duties, and substantive law is commercial law. All crimes are commercial, but that statement does not give you sufficient information to understand its relevancy. The law merchant or commercial law deals much with creditors and debtors, but a major invention of the merchants was securities, or having security interest in things which they do not possess or own. Possession. Another important invention of the merchants was imprisonment for debtors, which is why a community of nations of subjects or quasi-slaves is important. And just an aside, just the things from medieval times to maybe the mid 1800s, I think, about we had debtor prisons even in the United States and America and many other nations. Rather than say all crimes are commercial, the picture would be more clear if we said all crimes pertain to slaves. Whoa. If we understood that all crimes involve those who have a commercial obligation to another, and according to general law merchant theory, the property of a debtor and the body of a debtor is security for his debt, then you might see the slave relationship. Before you get to the concept that the body of a debtor is security for his debt, which is why prisons are overflowing, you need the potential debtor to be a slave with respect to the superior political authority, even though the same individual appears to be free with all respect to others and may even be unaware he has a slave relationship. I need to direct you to the treatise, A Society of Slaves and Freedmen, for a more comprehensive discussion on the topic. Let's jump over here to the chat and see if we're still up to date here. And we have here, there's a Metal. Welcome. Whoa, this is getting good, Tribe. Yeah, this is a really good text here. Craig Carey says, I can see why this wasn't required reading in government daycare. Positive law sounds pretty negative. Yeah, they don't use the word negative law, but that's probably where it belongs. We got positive law, dispositive law, substantive law. All right, let's continue. Slaves are commercial property or commercial persons. The law merchant is designed to operate in a society of quasi-slaves, known as freedmen, or in the English feudal system, known as villeins. For the merchants to reap wealth from their securities, the natural resources must be out in the marketplace, producing more and more wealth and applying for more loans. The revenue can then be extracted from fees, taxes, and licenses, permits, registrations, inflation. Sound familiar? Recessions, monetary cycles, statute penalties, insurance, and bonds can be implemented to cover down time while the producers are incarcerated. Bonds. The producers must be laden with payments on loans when no actual loans occurred in the merchant-controlled banking system, etc. The principles or rules of law merchant are generally known by the proceedings of medieval fairs conducted by the great merchants. Interestingly, these fairs in England were conducted in places where the inhabitants were villeins. Villeins owe obligations to a master in a slave relationship, but appear to be free to all others. I refer to the villeins as quasi-slaves, and quasi-slave is a term used in Black 7th edition in defining emancipation. To free a slavery is called manumission. The emancipation of a slave is merely a transfer, conveyance, or purchase. The emancipated slave was designated as a United States citizen that was subject to the superior political power of the government of the United States in its national sovereign character. The emancipated slave just took on a new master. The U.S. citizen has the characteristics of a villein. An example, a quasi-slave that appears to be free, but is still a slave to that superior political authority from which it receives substantive duties, rights, and obligations that are enforced according to adjective or procedural law. The quasi-slave is likewise subject to the political or special courts functioning under the so-called political branch of a national government. Congress called them freedmen, which is the same as villein or quasi-slave. So we get back here to manumission. To free a slave is called manumission. The emancipation is merely a transfer, conveyance, or purchase. And many may not be familiar with the term manumission, so this would behoove us to look over to Blacks, and let's look up the word manumission. Bear with me here because this is a scanned image of this and it searches very slowly. It's easier just to scroll to the page, but it'll take a second to catch up with our scroll. So let's get started. Manumission should be somewhere near the middle here. Let's see if we get lucky. And as we go along the way, we get the serendipitous benefit of finding some other gems along the way. Social guest towards a guest who is invited to enter or remain on another person's property primarily for private entertainment, as opposed to entertainment open to the general public. Wow, a licensee. Social guest. That's interesting. Because we have Jay-Z come perform at your party, and he's a social guest, right? All right, see here. L. Librarian. An officer charged with the custody of an organization's books, periodicals, and other published material. All right, it's catching up here. We just passed it. There we go. Management. Malware. Wow. So this is 9th edition. We can see emancipation while we're here. Emancipant, one who transfers property by emancipation. There we go. Emancipatory by will. Slave. Wow. Emancipium, Latin slave. A slave, especially by virtue of being captured in an enemy war. Temporary quasi-servile status, necessarily occurring in emancipation. And also when a master. Wow. Well, we could keep going on this for a while, but I didn't realize that emancipation really is a temporary quasi-servile status. But manumission, on the other hand, has a little bit better of a slaughter. We're getting there. I don't want to jump it too fast because it's rolling with me here. Manumission. Wow. Getting there. Come on. All right, we're there. Manumission. Let's make sure we're fully in here. All right, here we go. Noun, Latin, 15th century. I send out of hand. So mano, right? Manu. So hand and mission. Oh, I send out of hand. The granting of freedom to a slave. Jeez. In the Republic and early Empire, there were 3 usual methods, all of which made the freed slave a citizen. These were manumission, vindictica by the rod, a fictitious lawsuit in which a liberator touched the slave with a wand or rod in the presence of the praetor and alleged that he was free. Manumission sensu, by which the slave's name was enrolled in the census as a citizen. Wow, you get listed as a citizen and you're freed by that. You can point to your name on a list. I'm free. And then manumission testamento, by will. Under Justinian, a grant of freedom in any form except in fraud of creditors. Jeez, made the slave free and a citizen, also termed manumissio. So, here's the good part here, this little caption. Manumission is a kind of new birth. The master, patronus. Okay, so the master's there when they touch him with a rod. I get it. Therefore, stands to his freedman in a relation analogous to the relation between father and son. The patron, such as is entitled, as against his liberatus, to a father's right of succession and guardianship. Wow. To a father, he's entitled to a father's right of succession and guardianship. He has a right of moderate chastisement, levis coercio. He has the same claim to be treated with respect as he has against his son. He could claim to be supported by the liberatus. If he falls into poverty, he is, lastly, entitled to certain services on the part of the freedman, which he can, if necessary, enforce by action, provided only the freedman has promised them after his manumission and in a manner not derogatory to his liberty. So, There was something else in here about manumission. Prince of the master, stroke of the pen. That's a sensu. But I know there was something else in here. Massive pain of the limb. Jeez. So the manumission sacrorum causa, the freeing of a slave by the master, solemnly declaring that the slave was to be free, while holding a limb of the slave, and promising to pay a sum of money if the freedman later departs from the sacra family rights. Wow, the master then turned around and released the slave, who became free, but was bound to perform the family rites. The freeing of the slave by will in either of two ways: the master's granting the slave freedom outright in the will, or the master's imposing on an heir the obligations of freeing the slave, in which the slave became the freedman of the heir. Yeah, so this is interesting here. One thing I do know is that it also affects inheritance too. So excellent. Manumission. The simple definition is the first one here. Send out a hand is what it literally means in Latin. And the definition we have here, where'd it go? Granting a freedom to a slave. Okay. Man, this type's really hard to read on the scanned edition. I think for any of you that stuck with me through that digression, let's get back to the book. Metal Mel says quasi, like the public servants that try to stop our audits. Exactly. They're very quasi. All right, let's go back to the book here. All right. To free a slave is called manumission. The emancipation is merely a transfer, conveyance, or purchase. The emancipated slave was designated as a United States citizen that was subject to the superior political power of the government of the United States in its national sovereign character. The emancipated slave just took on a new master. The U.S. citizen has the characteristics of a villain. An example, a quasi-slave that appears to be free but is still a slave to that superior political authority from which it receives substantive duties, rights, and obligations that are enforced according to an adjective or procedural law. Adjective or procedural law. Adjective. The quasi-slave is likewise subject to the political or special courts functioning under the so-called political branch of a national government. Congress called them freedmen, which is the same as villain or quasi-slave. A foundational element for the operation of the law merchant, substantive law, positive law, administrative law, etc., is slavery. That's your foundational element, slavery. But deception is important because the law must not appear to be based on slavery. It can't appear to be based on slavery. With that in mind, while the great merchants operate behind the scene with their security interest and control over the national resources, it must appear that the ordinary de jure system of the country is continuing, even though the changes are occurring. The government becomes trustees for the great merchants, overseeing or administering the assets or affairs of the security holders. This is known as administrative law, operated in a large part by a level of trustees known as administrative agencies. For some time, the sheer amount of law, the substantive rules that regulate private conduct and direct the operation of government made by the agencies has far outnumbered the lawmaking engaged in by Congress through the traditional process. Legislating, huh? Rule is an agency statement designed to implement, interpret, or prescribe law or policy. Designed to implement, interpret, or prescribe law, so rules are not law. When agencies are authorized to prescribe law through substantive rulemaking, the administrator's regulation is not only due deference, but is accorded legislative effect. Wow. So it's not only due deference, it's legislative effect. To prescribe law through substantive rulemaking. So they take the law and they say, oh, it says this in their substantive rulemaking. It's due deference and legislative effect, and grants rights to impose obligations on the public. In some, they have the force of law. The constitutional independence of the administrative tribunal presupposes that it will perform the function of completing unfinished law. No presumption there, huh? The rise of administrative bodies probably has been the most significant legal trend of the last century, and perhaps more values today are affected by their decisions than by those of the courts, review of administration decisions, etc. Administrative agencies have been called quasi-legislative, quasi-executive, or quasi-judicial, as the occasion required, in order to validate their functions within the separation of powers scheme of the Constitution. The mere retreat to the qualifying quasi is implicit with the confession that all recognized classifications have broken down. And I think this takes us back to the 7 points of commercial instruments and that completeness. And then having this quasi thing, it's like it leaves some questions unanswered as far as something that could be attacked there as far as the legitimacy. Do you get the impression that someone has taken control of the regular de jure government and that an outside force is at work, placing people in positions as heads of administrative agencies that are creating legislation and regulations through substantive rulemaking, commercial law, merchant law, and who grants rights to and impose obligations on the public? Also, the true constitutional judicial powers have little to do in this system. They merely review substantive law or procedural law concerning these law, merchant, administrative affairs on the rare occasions that the judicial power is actually used. And we went over a good live stream on the Administrative Procedure Act. That's 5 U.S.C. 551-4, provides that a rule is an agency statement designed to implement, interpret, or prescribe law or policy. When agencies are authorized to prescribe law through substantive rulemaking, the administrator's regulation is not only due deference, but is accorded legislative effect. Now we know about the Chevron deference case and other aspects with administrative law and recent higher court decisions that have been setting judicial precedents for the ways that administrative agencies can interpret laws that go beyond what they've written down. So if it's not clearly written and specified in their rulemaking, it's how they're prescribing law, that they can't go and further interpret it in the courts, that it has to go strictly by what's written, and if it's not, it has to be deferred back to the legislature, not to the administrative agency that didn't clearly articulate the way they want the law prescribed or interpreted. They can't do interpretation outside of their rulemaking, and that's when it goes to court. It has to be looked at according to what they have in their rules, and no further interpretation can be done to be deferred back to the agency. It would defer back to the legislatures, and I believe that's still pretty active out there in the courts, and an interesting one to keep track of because it does touch close to home when we're talking about administrative agencies. Administrative law, the law governing the organization and operation of the executive branch of government, including independent agencies, and the relations of the executive with the legislature, the judiciary, and the public. Administrative law includes the statutes endowing agencies with powers and establishing rules of substantive law relating to those powers. It's from Black's Law 7th edition. We were checking earlier from the 9th. The legislature could not, by adopting the Code of Criminal Procedure, change the substantive law of the state because no such authority was conferred by the Constitution. In the Rodosta case, we pointed out the difference between substantive and procedural law and said that, as relates to crimes, substantive law is that which declares what acts are crimes and prescribes a punishment for committing them. Procedural law is that which provides or regulates the steps by which one who violates a criminal statute is punished. So it declares what acts and prescribes a punishment. And the procedure says what steps are done to someone that's accused of a criminal statute, right? A statute relating to the criminal procedure is a law, but not substantive law. The term law includes substantive law and adjective law, or the law of procedure. Substantive law, speaking broadly, is that which creates duties, rights, and obligations. It orders and permits and forbids and announces rewards and punishments. That's your substantive law. As relates to crimes and offenses, it declares what acts are crimes and prescribes a punishment for committing them. Adjective or procedural law is that which provides a method of enforcing and protecting such duties, rights, and obligations as are created by the substantive laws. Substantive laws is saying, like, I guess this is kind of how we have our statutes, and then the procedural laws would be the codes. The statutes say what needs to be done, the codes say how to do it. As relates to, well, at least in Florida, that's the way it is. As relates to criminal prosecutions, procedural law includes within its meaning whatever is embraced by the three technical terms pleading, evidence, and practice. As relates to criminal prosecutions, procedural law includes within its meaning whatever is embraced by the three technical terms pleading, evidence, and practice. And don't think that any of these things are easy terms. I've done about 20 on evidence already. All right, 20 live streams, on the law of evidence. This is nothing simple. Same with pleading and practice. In those words, do you see the statements as addressing free people? Oh, no. Or do they sound like a system of commands and prohibitions for slaves? Yes. Do free people knowingly authorize a servant legislative body to adopt a code that will grant them their rights and creates obligations? This is the law merchant and how merchants control nations. All right, so we'll be on to the next part, section 4, for the next live stream. We're about halfway. We've gotten about halfway through the book, maybe a bit more. And I think there's some appendices at the end, so we're probably even more than that. Diesel for We the People Do says you must use substantive law to be clear before they could proceed forward on procedure. Exactly. Well, I'm glad you guys are still here and listening, because I know this has been one very deep topic, but one worth knowing, because as we see, this touches every aspect of all of our lives anywhere in civilization around the world. No matter what laws, the law merchant has integrated itself into them and continues to do so more and more and to a higher degree all over the world. And by recognizing it and how it's being done, mainly through deceit, is the only way we can arm ourselves to be prepared to defend the rights and liberties and our God-given rights that we're supposed to be here to defend, that this country was set to do it for its posterity, that we have a duty and an obligation to reciprocate for our posterity. So with that said, I'd like to thank you all for attending. I sure hope you all will be here for the next one, where we'll continue with part 2 of the Law Merchant. We have one more comment here from Diesel We the People. I asked attorney why they don't use substantial law, and he says too complicated. Of course, they just want to argue evidence and procedural things. Substantive law is too complicated, of course. The procedure is just so simple and straightforward. It's very linear, and it doesn't require a deeper thought, the abstractions and synthesis that comes along when you look at a higher level of why you're doing things and not just what you're doing. So yeah, I could see that being a common sentiment among that trade. Well, with that being said, I'd like to thank you all for coming out. Please make sure you hit that bell notification, get notified, because I notice notifications get kind of slim. But then again, I do appreciate you all with the choices out there for drama and excitement that you spend the time here to learn about these substantial topics. And salute to you all. Peace out. I'll see y'all in the next one.